behalf of Joshua Gordonier.
Joshua Gordonier.
Thank you. All right, we're here today for sentencing in this matter. Have you had an opportunity to review the pre-sentence investigation report with your client?
I have, Your Honor, and we do have a few comments about the report.
Do you have corrections, additions, or deletions, or just comments for allocution time?
Just comments for allocution time. Well, one correction with the jail time credit. Mr. Gordonier believes he has more than 16 days.
All right, what is the time that you're asking for, Ms. White?
He believes he has 21 days.
1 minute.
I'm trying to look that up.
Well, he was arraigned on August the 29th. And he was given a PR bond at that time, an alcohol tether. He was in custody again on February 8th. He was in at least through February 15th, February 22nd. But I don't know when he went in. I just know when he was arraigned. So he has at least. Ms. Straub?
Hello, Your Honor. So he had 15 days the last time that he was in, from 2/7 to 2/22. And then the only other time he was booked into Washtenaw County after this incident occurred was 8/28 to 8/29 of 2023. He was booked in 2019 prior to that. So he's only been in Washtenaw County Jail for 16 days total since this offense occurred.
Okay. He's saying okay.
All right. Thank you. All right. And then the rest is comment for allocution. Is that correct, Ms. White?
That's correct.
All right. Ms. McDuffie, anything from the people?
Your Honor, so I think the recommendation is appropriate. I think one of the concerns, in addition to the actual incident, is of course we had a rather long drawn out hearing with, I think, the single drinking violation that Mr. Gordonier had in this case. And it seems like an anomaly for him to have been doing so well and have that one event, but Mr. Gordonier has a history of different sorts of drinking sort of incidents that are years apart, which is always concerns me because it's people who seem to be able to seem like they have a handle on a drinking issue, but they don't truly, because there's a prior case that we couldn't enhance this to because it was outside of the range. There's a disorderly drinking incident, I think, a couple years ago. So alcohol has a role in his life that I don't know if he truly grasps, especially given the hearing that we had and how that went. So I hope that he takes this opportunity to really sort of get in touch with that and to figure out what's going on and to be willing to address it once and for all.
Thank you. Ms. White?
I think Mr. Gordonier was very honest during his assessment, and I do think he understands everything. He and I have had conversations, and I think he gets that he's an alcoholic, and I do, to his benefit, as I said, was very honest during his assessment. As far as the report, he does want the court to know that he did not have suicidal ideations. He was drunk and made an offhand comment to the nurse. So he shouldn't have said what he did, but he said it was sort of an offhand comment that was made to the nurse, and most likely was due to his being drunk. And it was not a good comment to make.
All right.
And we do ask, as far as the recommendation, he would like to stay on the scram tether instead of testing 4 times a week.
Thank you. Mr. Gordonier, sir, is there anything you would like to say before I impose sentence?
Yes. Yeah, I do realize that I have an alcohol problem, and that's, it has been a problem, like the McDuffie said, Miss McDuffie said. So it's something that I want to, take care of. And I would like to stay on the scram tether, and not report, throughout the week due to my job. It makes it easier. That way, my boss doesn't get mad that I have to be late a couple hours or leave early. So if I could stay on that, it'd be great. But other than that, I have no problem doing a class or, whatever you think that is best.
Mr. Gordonier, I obviously had some similar concerns as the prosecutor regarding whether or not you understood the magnitude of your issue, but in looking at the assessment, it appears that you do. And so that is promising. That gives me hope that you will be able to get it together. And I'm sorry we had to go the route we had to go in this case. But I hope that you take this seriously, sir, and that you take the opportunity you're going to have here to try to get long-term, forever sobriety. I will follow the recommendation of the probation department, with the exception of the scram tether. I will allow you to use what you think is best for you to be able to report and show the court and yourself that you're doing what you need to be doing. It is the sentence of this court that you serve 180 days in the Washtenaw County Jail. Credit for the 16 days that you have served. The balance of that time is suspended, sir. Meaning you don't have to do any additional jail time as long as you follow the orders of the court and do what you need to do here. I am going to give you 8 days for a total of 64 hours of community service, 18 months on probation, fines and court costs in this case for a total of $695, $30 per month of probation oversight fee. Complete an assessment with Growth Works and follow all of their recommendations, and sign a release of information for the probation department, and schedule an assessment within 1 week of this sentencing. Attend the MAD Victim Impact Panel within 45 days of sentencing and provide a certificate of completion of that to the probation officer. If we don't have the certificate of completion, then we don't know that it's done, and you won't get credit for that, and you can get violated. Report to the probation officer monthly via the online reporting platform, and meet with the probation officer when and where directed, including any and all home visits. There's no use or possession of alcohol, marijuana, illegal drugs, drug paraphernalia, or firearm components, ammunition, or other dangerous weapons, and no being in the presence of anyone carrying or using those. You're to continue on the scram tether until we determine otherwise. Your vehicle will be immobilized for 90 days. You're to attend the 12-step meetings 2 times per week and provide proof of attendance to the probation department. We'll do a review in 60 days, and that's going to be on May 30th, 2024 at 10:00 a.m. Do you have any questions about any of that, sir?
So I have to go meet with my probation officer tomorrow or today.
You're going to call the probation department, and they usually do it over the phone, so you don't have to show up there. They send you a copy of the contract. You have to sign it and send it back. So you have their phone number. I'm going to give it to you again.
I'm ready, man.
734
Mhm.
483 7336.
483.
7336.
All right.
Thank you, sir. Take care of
Thank you,
yourself.
ma'am.
Bye-bye. The court will call the McBray matters 20S00203, 21S00313, and 19 FB 1608.
Rachel McDuffie for people.
Assistant Public Defender Allison Mueller here on behalf of Ronnie Magbray. Looks like he's getting unmuted right now.
Thank you.
Ronnie
Mr.
Magbray.
Mag. Thanks.
Thank you. Good morning, Mr. Magbray.
Morning.
All right. In these matters, we're here for a couple of pretrials and a sentencing.
Yes, Your Honor. I met with Mr. Magbray yesterday at the jail. I did go over the offers that were, I think, placed on the record at the last pretrial. And I think we're in the same situation we were in at the last pretrial. Mr. Magbray would like to move forward with the offer on the 20S case, which I believe Ms. McDuffie offered time served. So I'm not sure. I know the court at the last pretrial didn't want to move forward with the one plea, but not to the 21S case. At this time, Mr. Magbray is not prepared to plea on that until he has a better understanding of what is happening with his felony cases.
Well, the reality is we're not going to be waiting for the wet felony case. That's a murder and it could take up to 2 years, and that's not going to happen.
I understand, Your Honor.
Just to be clear, Ms. Mueller, when you say his felony case, my offer in the case that he was not ready to plead on meant that the sentence was going to be determined and incorporated with what the recommendations were for his previous felony case that he was set to be sentenced on in this court. So I just want to be clear that he is not, I understand waiting for that, I guess, recommendation, but just not the homicide.
Okay, set for you said the original felony that's set to be sentenced in this court.
So case number 19 FB 1608 was originally charged as a felony, was remanded here. That's the
I
case
understand.
that his,
Okay.
Yeah.
Okay, I understand. And I guess that might be the determination then. Can that be sentenced today, the 19 FB case? I didn't receive I don't know if there should be a report or.
There's no report until I'm not going to sentence him. I'm not going to piecemeal this. We're going to do one sentencing at one time. So once we've resolved the pretrials, which if he's not going to plead to them, we're going to set them for a trial date and
I
move
understand.
forward.
Okay, Your Honor, I understand now. I'm sorry for the confusion. If I could speak with Mr. Magbray just very briefly in a breakout room, then I think hopefully we'll be able to decide one way or another.
Okay, thank you. We'll put you in the breakout room. The court will call the case of the state of Michigan versus Talia Argo, case number 22S00535.
Rachel McDuffie for people.
Ms. Talia Argo, please unmute your device, turn on your screen, ma'am, and state your name.
I'm not sure. Okay.
Thank you. Please state your name.
Talia Argo.
Leah, thank you. All right, Ms. Argo, you're here today because your probation has expired. It appears to me that you have been, you were compliant with the terms there. You were compliant with your terms here. So you're being discharged from probation. Thank you for completing your probation with the exception of your fines and costs. So do you have a plan for how you want to play off your fines and costs, ma'am?
Yes. I was in the process of appealing my Social Security disability. And I just got a letter on the 20th saying that it was going to be restarted. So I should get my first check on April 3rd. And I can make payments starting from April 3rd.
All right. Then why don't we set you up for the 15th of each month, starting in April? How much can you make per month, ma'am?
Probably 200.
You can make $200 a month. Don't
I
over.
can, yeah, because I don't want to get in trouble for like not paying the
Alright.
fines.
Are you sure you can make 200? I mean, I can set you up with that if you're sure you can make that. But if not, we can do 100, 150, something that you know you can make, because otherwise you can get in trouble for not paying the part that you said you were going to pay.
Okay, well, can I agree to 100? And if I'm able to pay more, just pay more?
Yes. All right, I'm setting you up for $100. You're gonna pay more if you can. June 27th, 2024, at 10 o'clock is your next court date, okay?
Okay.
If you're making your $100 payments, then you don't have to be here. Or making more, you don't have to be here. If you're not, you need to come back so we can talk about why that is, okay?
Okay,
All right, see you on June 27th. Take care.
thank you.
Bye-bye. State of Michigan versus Delonte Napier, case number 24 FB 1007.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Delonte Napier.
Delonte Napier, please unmute your device, state your name.
Delonte Marion Napier.
Thank you. We're here for sentencing today. Have you had an opportunity to review the pre-sentence investigation report with your client?
Yes,
Yes.
he did review the report with Ms. Moeller, and they do accept the recommendation, and we are ready to allocate when ready.
Thank you. Ms. McDuffie, anything from the people?
Just echoing the same concerns and observations that are in the report, which is that I believe Mr. Napier knows that his story is not credible. And going to get an inhaler doesn't equal a door kicked in with so much force that the trim was completely torn off of it. So I just hope that he can get real with himself about his actions, his anger, jealousy, of whatever it is. But whatever it is that caused him to get here, because we don't want him to end up here again if he doesn't get a handle on it. That's all.
Thank you. Ms. White, what would you like to say?
Mr. Napier has learned from the experience and is eager to complete his probation requirements.
Yeah, what would you like to say? Mr. Napier.
What you said? What I like to say? Yes.
Can't hear me because of
I'm
all
gonna.
the what's going on, sir?
Huh?
You can't hear me because of all the background noise going on.
Yeah, my son watching cartoon. I'm gonna turn the TV off.
Okay.
Yeah, I can hear you now.
All right. Well, is there anything you would like to say prior to sentencing, sir?
No, I'm gonna finish all my all the things I need me to follow. Y'all got a restitution price where I can pay it up front.
Restitution is reserved for 60 days, so we don't have that number yet, sir.
Okay.
Anything else, sir?
No.
All right, I'm gonna follow the recommendation of the probation department. I, like the prosecutor, also hope that you take this seriously and that you try to figure out the truth behind why this happened and that you don't do these types of things in the future, okay?
Yes, ma'am.
It is the sentence of the court that you serve 24 months on probation. Your probation agent is gonna be Ms. Johnson. 365 days in the Washtenaw County Jail, credit for 10 days served. 355 days are suspended, meaning that if you do what you're supposed to do, then you don't have to do any additional jail time. If you don't, you're looking at 355 additional days. Do you understand that, sir?
Yeah.
All right. Fines and court costs in this particular case for a total of $525. Meet with probation when and where directed, including any and all home visits, weekly phone reports, and probation group meetings. You're to attend and complete the ABR Domestic Violence Early Intervention Program. You're restricted from having any alcoholic beverages in the home. You're to pay and be responsible for random drug and alcohol tests as requested by the court, probation, or police. You're to provide monthly verification of compliance of all completed conditions to the probation department. You to attend court reviews as ordered by the court and provide proof of compliance. Make earnest efforts to maintain legitimate employment. Restitution in this case is reserved for the 60 days that we talked about earlier. There's no contact with Devasha Morris, no going to her place of employment or residence, no use or possession of alcohol, marijuana, illegal drugs, drug paraphernalia, no being in the presence of anyone using those, or firearms, firearm components, ammunition, or other dangerous weapons. And we'll do a review in 60 days. That is going to be on May 30th, 2024 at 10 o'clock a.m. before me. We will see you then. Do you have the phone number for the probation department? When I gave it out earlier, sir.
You said, do I got a job number?
You have the phone number for the probation department, sir.
Yes, I got it. I got it saved in my phone.
All right, please call them tomorrow after 9 o'clock a.m. so they can go over your probation contract with you, okay?
Okay.
All right, thank you, sir.
Thank you.
Have a good day.
You too.
The court will recall all of the Ronnie McBray matters.
Rachel McDuffie for the people.
Assistant Public Defender Allison Mueller here on behalf of Ronnie Magray. Mr. Magray, can you have them unmute you again and state your name for the record, please?
Ronnie Magray.
Thank you. Ms. Mueller, where are we, please?
Yes, Your Honor. So I had a chance to talk with Mr. Magray further. What he would like to do with both of the cases set for pretrial today is set them for trial.
All right. Final settlement conference in these cases will be on April 25th at 2000. Thank you. I'm sorry. Final settlement will be on April 25th, 2024 at 11 a.m. And jury selection will be on May 3rd at 8:30 a.m. Will continue in all of these matters, and we'll have the 19 FB case tag along to that final settlement conference date.
Okay, understood. Thanks, Your Honor.
We'll see you then, sir. State of Michigan versus Mariah Cotton Brooks, case number 19 FB 7733.
Rachel McDuffie for people.
Assistant Public Defender Sandra White on behalf of Mariah Cotton Brooks.
Now, please state your name.
Mariah Cotton Brooks.
Thank you. Good morning.
Good morning.
We're here for a review. Ms. Mariah Cotton Brooks is supposed to be making payments of $75 per month on the 22nd of each month. Where are we with that?
It looks like Ms. Cotton Brooks made a payment on March 14th of this month. Is that correct, Ms. Cotton Brooks?
Yeah, I was late last month, so I made a payment on the 14th.
All right. And you've been making the payments otherwise, though?
Yeah. I'm waiting for my my husband's check to get in the checking account so I can make the payment for this month as well. He gets paid today, so it should be here soon.
I'll bring you back on June 27th, 2024 at 10 a.m. to see if you're continuing to make your payments. Thank you for making them. We appreciate you, ma'am.
No problem. Have a
You're
good
welcome.
one.
Good day. Bye-bye.
Bye.
Yeah, 10 a.m. No shows that I need to do.
No. I missed anything custody.
All right. All right, we're gonna wait for them to bring our next in custody person. We'll be on recess until that occurs. Mr. Martell, do you need to see your client again? Mr. Martell, do you need to see your client again?
Very briefly, Judge, please and thank you.
Thank you. We'll put you in a breakout room. All right, the 14B District Court is back in session. Court will call the case of the State of Michigan versus Jordan Moretta, case 23 FB 1540.
Rachel McDuffie for the people.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Edward Martell, P 85051, on behalf of Jaden Merida. Mr. Merida, please unmute yourself and state your full name for the record, sir.
Good morning, Your Honor. Jaden Merida.
Good morning, Mr. Merida. All right, Mr. Merida is before the court today for sentencing.
That is correct, Judge.
Have you had an opportunity to review the report with your client?
I have, Judge.
there anything you would like to say on behalf of your client or corrections to be made?
Judge, no edits, deletions, or corrections. I would say, however, Judge, certainly, while I have much respect for the probation department, the recommendation, Judge, shocks the conscience. I mean, the recommendation comports with the original charges, not with the charge of, or not with the, offense which was pled to, which is use. Certainly, statutorily speaking, it is a 1-year misdemeanor, Judge, but I certainly, Judge, it shocks the conscience that a year in the county jail would be recommended. Now, Judge, I will say this. Mr. Merida is undeniably dealing with and battling the monster of addiction and has been for some time, Judge, and I forwarded over a letter of acceptance to an inpatient treatment program, which was originally sent to Judge Slay. However, at this time, based on all the pending charges that he has, and certainly he does have other pending charges, Judge, Judge Slay has opted not to put him into the program as of yet, but it's certainly, I sent it over and forwarded it over to you, Judge, just to understand and appreciate what this young man is dealing with. And incarceration is not what he needs, it's treatment, Judge. So I'm asking Your Honor, in the spirit of justice, in the spirit of issuing a reasonable, fair, and proper sanction, Judge. I mean, if he was out, I would ask for fines and costs, but certainly I think a 30-day jail sentence is more than sufficient, Judge. He's done 92 days as of today. As of the date of the report, it was 83 days. So I do believe, and I'm humbly asking that time served with the 92 days is sufficient for the misdemeanor offense of use, Judge. That would be my humble request of this honorable court today.
Thank you, Ms. McDuffie.
Thank you, Your Honor, and thank you, Mr. Martell. My condolences to you, sir.
Thank you.
So I understand that it may seem a little bit, I guess, odd, probably excessive to counsel, that somebody who's had a reduction on a charged offense is sentenced to the maximum penalty. But I don't think that the recommendation for him serving the maximum term is done with blinders on to all of the surrounding circumstances. And I think part of that takes into account the circumstances of the offense itself. Yes, he pled to use, but there are very concerning circumstances in this case regarding the behavior that Mr. Merida exhibited when we're talking about attempting to flee from police officers and rolling your window up on their arm while they're speaking to you in the vehicle. That could have gone horribly. I don't want to say wrong because it's already wrong, but a lot worse, right, than it did. We have to take into account, again, his history. He has multiple cases that he had going on prior to this in Wayne County with extremely serious and concerning charges. And he has, as was mentioned, a brand new felony that he, well, not brand new, but the offense date is October of 2023, that he was just arraigned on a few days ago. And that's possession with intent to distribute a very, very large amount. I frequently say that this will be in what Wayne County calls the major drug unit with this quantity. So yes, I agree. Mr. Merida has a substance abuse issue, and I absolutely believe that he should get treatment for it. But I can't agree that the sentence of jail is inappropriate. He was just sentenced to time served on one of those Wayne County cases, but he had already pretty much done a year there. I think that a jail sentence is appropriate in this case, given the underlying circumstances, the history that he has, and again, not just drug use, not just drug sale, but I put on the bond recommendation form when I charged this case originally. The flight risk concerns for him extend to this case. He has previous fleeing cases. We have to be able to keep track of him. So he's displayed that behavior over and over again. And so we are concerned about him, his safety, the community safety, and his own health. So I think the sentence is appropriate. I will defer to the court in terms of a release to treatment. I would ask for some sort of tether, if it's possible to tether him to a treatment facility, if at all, given everything that we know and I've just discussed. But I think the sentence is appropriate. I don't think it shocks the conscience at all. I think it's right in line with where Mr. Merida finds himself right now at this stage of his life. I hope that this is a turning point for him.
Judge, if I may briefly rebut, very briefly.
Very briefly, sir.
Thank you. To be clear, Judge, Mr. Merida is on remand from Judge Slay. While he's been accepted into the program, he's not going into the program as of yet based on the new pending charges. And we're certainly not saying that a jail sentence is not appropriate here. The amount of jail is what shocks the conscience, Judge. He's done 92 days. We're asking for 92 days county jail time served. The probation department is asking for a year. And Judge, certainly not to be rewarded for other pending conduct, but he has bigger fish to fry. We certainly have ostensible defenses on all of these pending matters. But in this particular case, we're talking about a couple of oxycodone pills to which this young man was using. It shouldn't have been, of course. We're not talking about a large quantity, Judge. And certainly he did, admit to not, opening the door when ordered and et cetera, Judge. But again, based on the conduct, a year in jail is excessive, Judge. We're asking for 92 days time served, so he can again move forward with defending against the other present matters. Thank you, Judge.
Thank you. Anything from you, Mr. Merida?
No, Your Honor.
All right. I agree with the prosecution. I don't feel like this shocks the conscience at all. I feel like this is, well, first of all, let's start with the fact that you're saying that he has 92 days. I believe that the way the probation department does this is they project what the time period is going to be at the time of sentencing, not for what was at the time they wrote the report. So this 83 days is at the time that we're sentencing him today. Is that correct, Ms. Straub?
That is, Your Honor. I just verified in XGL that he has 83 days as of today.
I stand corrected.
So that's the first piece of this. And then secondly, was originally charged with controlled substance possession, police officer assaulting and obstructing. There were 2 counts of that, reckless driving and use. And in this particular case, it sounds to me like the facts of this case are very serious. And the fact that something was reduced to a misdemeanor doesn't mean that one is entitled to credit time served. So I wholeheartedly disagree with your interpretation of that. And the fact that he needs treatment is something that this court will, of course, take into consideration, but not in the way that you're asking me to. I'm not going to give him credit time served and say, good luck with that. No, I'm going to hang some jail time over his head. I will release him to treatment if at some point in time Judge Slay decides to do that. It is a sentence of this court, sir, that you serve 365 days in the Washtenaw County Jail. You will get credit for 83 days served. You may be released to this program, which sounds like a wonderful program, actually, the Abundant Community Recovery Services Program, to complete their long-term inpatient, a holistic approach to treatment for you. It sounds like you've had a lot going on in your life in the past, and that this is something that you need. And whether you're given that opportunity will ultimately be up to someone else. But on this particular case, that is your sentence, and I will do that with a GPS tether so that we make sure you stay there. Okay? And if you leave that, you'll come back and you'll finish your sentence.
Just for clarity, he's got a year in the county, essentially 12 months in the county, but can be released upon as far as on a GPS tether to Abundant Community Recovery, correct?
Correct.
Perfect. Thank you, Judge.
You're welcome.
Thank you, Your Honor.
You're welcome.
I'll have a great day. Thank you.
You too. Thank you, Pastor Wade. All right, we're gonna do our in-persons now. Is someone available to come down to handle the Moody and the Ellis matters?
Yes, Your Honor, I'll be down to handle the Ellis matter, and Ms. White will be down for the Moody matter.
Thank you. Yes, I can.
Yeah, what about yours? Yeah. Right.
You said you know how much the.
I had one do that one time. She was trying to keep my veins pop out here.
I do sometimes. I don't get to see it too much. Throughout the year, but before I came to this garden, sometimes I didn't see it. Have you worked with them? Oh, okay. Yeah, I like it. You should be the show.
I had my gallbladder. I was drinking it, so then your veins. And I'm like, yeah, so do it here because that's what does it. They're trying to this. Start hurting like okay, I could take some pain.
Yeah.
All right. Seriously. Then I'm like, look at that. You did that picture. Oh yeah. Sorry.
Just make sure your phones are off. All rise. Board to be court is now in session. Honorable MIWashington presiding.
Thank you. You may be seated. All right, the court will call the Kara. Oh, no, it's the wrong person.
On Ellis, but if we need to go second, we can do that.
It's fine. So the court will call the matter of State of Michigan versus Devon Ellis, 23 FB 1258.
Rachel McDuffie for the people.
Mr. Public Defender Allison Mueller here on behalf of Devon Ellis. To my right, Mr. Ellis, can you state your name for the record?
Devon Ellis.
Thank you. Mr. Ellis is here today for a he appeared for the VOP on March 14th and he pled guilty to that violation for testing positive for an ETG on February 23rd, correct?
That's correct, Your Honor.
So we're here for sentencing today?
Yes, we are.
All right. Have you had an opportunity to go over the recommendation with your client?
Your Honor, I'm sorry. So when we were last here, we also learned at that time that Mr. Ellis had missed a lot of tests just in the months of February and March. And so the court was trying to determine whether or not he was going to be remanded or be sent to inpatient. And We returned today to see if he had any more missed or positive tests in the last 2 weeks. So I just wanted to know if the court and council has any updated information on his testing.
All right. Ms. Straub, are you able to give us updated information on his testing?
Mr. Ellis, Your Honor?
Yes, please.
Yes, 1 second, please. Can you remind me of the last day that we were here, Your Honor?
March 14th.
Okay. So he tested on March 15th. That's the only additional day I see. It looks like he was tested for drugs, not for ETG, although he was, he was PBT'd, and that was all clear, all negative.
So is that the only time he was required to show, or is that the only time he reported? I'm not certain.
So since March 14th, that's the only time he's been called. It looks like he was previously called on March 4th and he completed that ETG, and then he missed a test on March 13th.
Anything further from you, Ms. McDuffie, with respect to that?
Just that I thought he was reporting more. I guess I can't tell if he was scheduled to report more frequently than that, or if it's just the fact that because he had missed so often, those were also missed makeups that were included that make it look like he was supposed to report more often. But if he wasn't required to report beyond that, then we just have that one test to go on.
If that is the only one we have, and yours is the only one that he was required to test at that time. According to community corrections, I'm reviewing the orders here to see his testing frequency.
It looks like 3 times per month drug and alcohol testing. So that's what.
So he probably has one coming up here soon, but.
Okay.
All right.
Your Honor, they probably aren't going to call his number again. He was called March 4th, March 13th, and March 15th.
Oh, I see.
So he tested on the 4th and the 15th. He missed the 13th.
Well, he missed the day before his court hearing.
Yes, Your Honor. Before that, he has many missed tests in February, especially some in January. Several in January, actually, and all the way up until November of last year.
We were aware of that part. All right, thank you. What would you like to say with respect to the recommendation, Ms. Muller?
Sorry, Your Honor, I'm just pulling up the original or the recommendation. That was from the 14th.
The 14th, correct?
Sorry. So the recommendations being 5 days at the Washington County Jail to continue on with probation.
Right.
Your Honor, I know that it was the recommendation, and we court noted, discussed Mr. Ellis's history at the last hearing. I think I agree with what Ms. McDuffie said, is what we were doing here was setting it out to see if Mr. Ellis could comply in the 2-week interim. And I know it would be helpful if there had been more testing than just the one time. So that doesn't tell us a lot, but it does tell us a little bit. It does tell us that Mr. Ellis is able to comply. He is able to test negative. So at this point, I understand why the recommendation was made. I understand where Agent Straub was coming from, and given Mr. Ellis's history, but I think, as I said on the 14th, I would just ask the court to look at, what he's doing now, meet him where he's at now, and at this point, not follow the recommendation, given that he did comply with everything in this 2-week interim, and with the knowledge that the recommendation will just continue to be
steeper if there are any further violations. So that would be the defense's request, is ask the court not to follow the recommendation. At this point, I'm not sure what the 5 days in the jail would serve for Mr. Ellis. I know that that is, you know, allowed, that could be sentenced, but I don't think it would serve Mr. Ellis, and I don't think it would serve the purposes of this case at this point in time.
Thank you. Ms. McDuffie?
You know, the irony is that because Mr. Ellis missed so many tests, we aren't in a position to really truly evaluate if he's compliant or not, because we only had one more left to go for this month. But I want to, I don't take a position on whether or not he needs to get the 5 days in jail at this point. I think that the court's concern and mine too was that he seemed like he needed to be in treatment. And I know that he was originally ordered to get an assessment from Don Farm. So my question is really, has that been done yet? And where are we with him engaging in what he ought to be doing to address the underlying issue? I would ask that the 5 days in jail, if the court decides not to send him today, be basically held in abeyance, because Ms. Moeller, and I know that, you know, she can't really promise this on behalf of her client, but she was asking, you know, if he could have one more chance, and if he had one more negative test or one more positive test or one more missed test, and he was not going to miss or test positive again, which is a, you know, tall order. I would ask that that sentence be held in abeyance if that does happen, that we follow through on that at that time.
So what she's saying is she wants it to be the 5 days plus at the time if he comes back with another violation like this would be 5 plus 10 for a total of 15.
We understand that, Your Honor, and we'll argue against that recommendation. And I'm glad Ms. McDuffie brought up the assessment. Mr. Ellis did tell me, I believe he just received something in the mail. I think that was maybe from Agent Stroud. I'm not sure, I haven't seen what the letter was, but he is open to being assessed. And so we're also okay with, if that's a condition of the court, that he do that before his next review date here.
All right. Anything you want to say, sir?
No, ma'am.
All right. Sir, it's the sentence of this court that you serve 5 days in the Washtenaw County Jail. I'm going to hold those in abeyance. Like, I think that's a great recommendation from the prosecutor, because we only have the one test. I'm still concerned about whether or not you're going to follow this court's orders. So if you miss a test, you test positive, you're looking at 5 days plus 10 days for a total of 15. Do you understand that, sir?
Yes, ma'am.
All right, and you need to get that assessment done. So it's not just the violation for any of those things, it's any violation at all, except for if it's a non-technical, which means then you could do the entire time period. Okay. So I'm going to sentence you to that and do a review in 60 days on May 30th, 2024 at 10. So please keep it together.
You're
Yes.
Mr. Ellis was sent his probation contract electronically back at the end of February. It's been resent since then, but he still has not signed it. So if he could check his email and get that signed, that might help with his completion.
Do you have a copy he can come down and sign right now?
Sure, I can make another copy.
That's what we're gonna do. Sign your contract before you leave here, sir.
Okay.
Okay.
Thank you.
You're welcome. You're all set, sir. Do not leave the building until you sign that contract, please. So wait out there until she comes.
Okay.
Call Akira Moody matters. 18T 10949, 19W001843, 22W004236B, and 23S0085.
Rachel McDuffie for the people.
Up to finish on the way to behalf of Karen Moody, can you take the name of the record? Carter Moody.
I said it right the first time when I found it. All right. We're here today in this adjourned continuation of a violation of probation hearing. then Miss Moody wanted time to get a hair test done, is what I recall last.
And yes, she did look into it, and it was only a 90-day that she could find.
Well, we were here
We
on
were hoping-
February 29th, and she had until March 5th to do that.
Right, and she wasn't able to find one that could get one done for the 6 months, so that she could pay for it.
All right, and in that case, do you have any witnesses? Do you rest? Where are we with your part of the case?
I'm sorry?
We're at the stage where you were going to present your part of the case. Do you have any witnesses?
No.
Do you rest? What would you like to do?
We're ready to rest.
Ms. McDuffie, argument?
Your Honor, I have to apologize because it's been a number of adjournments since Mr. Hayes was here and spoke, I think so eloquently on some of the more scientific details of this. But I do recall that Ms. Moody's defense or argument with respect to the positive test was that she was undergoing some treatments. I want to be sure that I say it correctly. One moment. She was getting infusions for ocular sarcoidosis, which was supposed to be interfering with her tether. And Mr. Hayes was here and presented in quite some detail about how the sugar alcohols that are produced from the substance that would have been administered to her intravenously would have had no effect whatsoever on the scram tether. And that it essentially just was not possible for that sort of result to occur, because if there was very small amounts of alcohol used as a solvent in that solution, to register, the amounts would have to be so high that it would have to be 30 or 40 times the recommended amount to like even reach, a 0.02, let alone the levels that she was at, which were, I think, double that. So in short, I do recall that the court didn't have any questions following his presentation, that I believe he was very thorough. He's a credible witness. And quite frankly, I think that even the documentation that we received regarding this issue was a general sort of maybe, possibly be from the physician. One thing that stands out to me is that Ms. Moody, as we discussed, these violations were September of last year and October of last year, one each in each of those months. It was my understanding, and they can certainly correct me if I'm wrong, that this was a medical procedure that Ms. Moody needed to undergo on a regular basis. We haven't had any further violations. So if that were the reason for that, I don't know that Ms. Moody had, at the same time that her scram tether violations stopped, also stopped that treatment at the same time. Because if that were the case, I would expect that the violations would have continued if that's what we're going to attempt to blame this on. We've gone from that. Well, I won't get into the defenses that weren't presented, but basically the defense that was presented, I believe that we had witnesses that were credible and that we have proven that it's not a credible defense. There's not a way that could have happened. The court is familiar at this point with the scram tether system and the process for confirmed alcohol consumption and the 6 steps that must occur with the baseline being established, the time period, everything returning to baseline and at 2 points, all these things that have to happen before a violation is even held against someone. And so I don't see any other rationale here except for the fact that Ms. Moody violated. Ms. Moody has a history of violating quite a few times. I'm glad to see that finally she's had a bit of a stretch of time where she hasn't violated. But I don't think that this situation is explained any other way than what it appears to be on the surface, which is alcohol consumption.
Ms. Moody hasn't had any injections since December. So we believe that that's probably part of why she hasn't had any positive tests, and also being switched to the Soberline. She believes that probably has made a difference in the testing as far as not having any positive tests. When the court is ready, I do wish to allocate on her behalf.
With respect to the violation in this case, the doctor said everything that Ms. McDuffie, not the doctor, but the expert said everything that Ms. McDuffie said. He said, in addition to that, he also said that If this particular treatment had been the issue, that she would be dead because it would be going directly into her system, directly into her blood. That's not how this even works. So it was impossible for this to have occurred the way she's alleging that it occurred. So I find no basis whatsoever to find anything other than the fact that she actually violated her probation terms again. Not only did she violate, but now we've gone through 1, 2, 3, 2 adjournments, a hearing. Wait, there were adjournments before we actually had the hearing. So we've been doing this since December. The argument that because now she is no longer, or she stopped treatment in December, does not explain how from September to December it wouldn't have shown up the same way. And that's because it's not possible for this to be the effect, just like the expert said. So having said that, I find that she's guilty of this violation. What would you like to say on behalf of your client?
Miss Moody did turn herself in after the positive test. At that time, she did 11 days, and we asked that the court take that into consideration if the court is considering giving her jail at this time, that jail time be considered instead.
Actually, we don't, Miss, I think this is a Miss Stroud. One moment. Oh, I think she's meeting with someone else. We don't actually have a recommendation yet.
Okay.
I think what I'm gonna do is adjourn it to get the recommendation. And the other thing is, apparently she met with Ms. Geiger and didn't provide Ms. Geiger all the documentation that she needed to do a reassessment. So that hasn't been done either.
She has all her paperwork. I just have.
Ma'am, I got a letter from her right now saying she doesn't.
We'll look into that, Your Honor.
Ms. Strawberry, is there something you wanted to say? I was going to adjourn it for a recommendation from you.
No, I just heard my name called, so I wanted to make sure I was here.
Okay, got you. I called your name to see if there was a recommendation yet. Or
No, Your
if-
Honor.
Okay, so is it your recommendation at this time that I adjourn it so you can do some follow-up with Ms. Geiger? Because I do have this email saying that she didn't turn in her paperwork.
Yes, once Ms. Geiger has that paperwork, she should provide me with an updated assessment, and then as soon as I have that, I will prepare my recommendations.
May 2nd, 2024. At 10 a.m. For sentencing in person. No, I'm sorry, 11 a.m. in person. See you then. Thank you. And the other matters will tag along to that date as well.
Thank you.
Ma'am, you need to participate fully with Ms. Geiger in making sure she has all the documentation she needs to complete the assessment. Do you understand?
Yes, ma'am.
All right. All right, I'm gonna leave the polycom and go on to back onto Zoom. Good afternoon, everyone. Welcome to the 14B District Court. We're here today for final settlement conferences. I was trying to give everyone an opportunity to make sure that their cases, that their devices were connected when I give out the instructions. So we're here in court, so please treat this room just like it's a regular courtroom, except you get to remain at home in the comfort of your own homes. The way it's going to work is that the prosecutor and the attorneys will be the prosecutors and the attorneys will be talking in the background to try to see whether cases are ready to go or not ready to go. And they're going to give me a list of cases in the order in which they should be called. I will call those cases, and then if there are witnesses present, they will be excused, or and you'll know whether your case is proceeding, or whether we have a plea, or what we're going to be doing in the interim time period. And I thank you for your patience. We were handling a couple of in-person matters until just now, and that's why we're getting started a little late with our 11 o'clock docket. Okay, so I will begin calling cases as soon as they are ready. Attorneys, please make sure that the court clerk knows exactly what the disposition of the case is going to be, meaning what is going to occur, whether it's going to be a trial, whether it's going to be a plea, or something different, but we need to know what's happening on the case. All right. I will await a list of cases. There is an individual with a hat on labeled iPhone. Can you please unmute and tell us your first and last name?
Daryl Johnson.
Thank you, Mr. Johnson. There's an individual labeled iPhone with a 2 behind it. Could you unmute and tell us what your name is? Yes, sir, you with the second hat on. I guess you probably were confused since you have a hat too. What is your name?
Oh, Donovan Cox.
Thank you, sir. All right, the court will call the matter of Ypsilanti Township versus Zachary Wagan Schutz, case number 23T00846.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Michael Vincent on behalf of Zachary Wadnitz, who is coming into my office as we speak.
Thank you.
Conference room. Have a seat. State your name to the judge, please.
Zachary Wagan.
Thank you. All right, we're here for final settlement conference today.
That's correct, Your Honor. At this time, the township is not in a position to proceed.
Your Honor, I move for a dismissal.
All right, given that the people were unable to proceed, Mr. Wagan Schutz, this case is going to be dismissed. Dismissal is without prejudice, meaning that if they're able to proceed at a later date and time, they could reauthorize these charges. At this point in time, all of your bond conditions are now over, and this case is now closed. You're all set, sir. Have a good day.
Excuse me, I want to make it his bond conditions are over, correct?
Yes, that's what I said.
Okay. It's early in the
They
morning.
will not be
Old people.
officially canceled. Hold on one second. Until when? They will not be officially canceled until this afternoon, but his bond conditions are over. We have to put it in lien.
All right, thank you.
Thank you. Ypsilanti Township versus Daryl Johnson, case number 23T00482.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Mueller here on behalf of Daryl Johnson. Mr. Johnson, can you unmute and state your name for the record, please?
Mr. Daryl
Johnson.
Thank you. Sir, please take off your hat. Unless it's a religious item. Mr. Johnson, is your hat religious? Thank you. All right. We're here for a final settlement conference today.
That's correct, Your Honor. Counsel provided me with information about the appropriate insurance for the case, so at this point, I'm moving to dismiss.
Based on the request of the prosecution for a dismissal in this case, the case is now dismissed. You're all set.
Thank you.
Okay. Have a good day.
Thank you, Mr. Burnett.
All right. We'll be awaiting new cases to call. Who's handling the Buck matter from the PD's office?
Good morning, Your Honor. That would be me.
Are we ready on that yet?
From my position, we are, Your Honor.
We are, Your Honor. I sent a message on that. All good. And I feel like there was one more I sent to Ms. Ball, so we can call a few of mine.
Thank you.
The court will call the matter of the state of Michigan versus Everett Buck, case number 23S00386.
Rachel McDuffie for the people.
Assessment Buck is under Donvey Leba for Mr. Buck. Mr. Buck, could you state your name?
Yes, Everett Buck.
Thank you. Good morning, Mr. Buck.
Good morning, Your Honor.
You're here for final settlement conference today?
That's correct, Your Honor. Mr. Buck previously rejected the offer where he had begun to enter a plea a few pre-trials ago. We are ready to proceed to jury selection. I did get availability, so just to put it out there now, we would be able to go either Friday, April 19th or Tuesday, April 16th, it looks like.
Guess we're Tuesday, April 16th, because the Friday is not an option. Jury selection will be on April 5th, 2024 at 8:30 a.m.
Thank you, Your Honor. And I would also like to request a motion date for a motion in limine regarding the prosecution's proposed other acts.
That's the one I filed some months ago. Let me see.
You have to file a written objection to those.
My apologies, Your Honor. That will be filed. That will be filed shortly.
Well, we only have the 4th and 11th as options for the hearing date. So let's go with the 11th.
Thank you, Your Honor.
At 11 a.m. State of Michigan versus Kevin Allgood, case number 22-00659.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Kevin Allgood. Mr. Allgood, could you state your name for the record?
You're muted, Mr. Allgood.
Sorry about that, Your Honor. I was trying to unmute it. Kevin Scott Allgood.
Thank you, Mr. Allgood. Thank you for dressing up too. I appreciate it.
Your
All
Honor,
right.
may we approach on this matter?
Yes.
So all my life I had, like, I swear to God. How you send a judge a message and let her know like you got something on the floor, you trying to hurry up and go? Show me that shit real quick, Mike.
Mr. Allgood, we're gonna put you into a breakout room with your attorney at this time.
Yes, Your Honor.
Thank you. The court will call the case of the state of Michigan versus Sean Williams, case number 23 FB 2418.
Rachel McDuffie for the people.
Rodriguez for Sean Williams.
Sean Williams.
Thank you. All right, we're here for final settlement conference today.
Yes, Your Honor. At this time, the people are unable to proceed in this manner.
And we would move to dismiss.
Thank you. Mr. Williams, given that the people are unable to proceed, sir, I'm going to grant your attorney's motion to dismiss. The dismissal is without prejudice, meaning that if they're able to proceed at a later date and time, then this case could be reauthorized. But at this point in time, all your bond conditions are over. I see that a surety bond was posted that will be returned.
Okay.
Thank you, sir. Have a good day.
You too.
State of Michigan versus Darius Caldwell, case number 23S00532.
Rachel McDuffie for the people.
Rodriguez on behalf of Darius Caldwell. Mr. Caldwell, if you could ask someone to unmute you.
Please state your name, Mr. Caldwell.
Yes, Your Honor, Darius Caldwell.
Thank you. We're here for final settlement conference today.
That's correct, Your Honor. This is the case that the people were prepared to proceed on without the victim. However, the officer necessary for this case is out on paternity leave, and I unfortunately do not have an exact date for his return. I believe it'll be sometime next month, but he told me back in January that he knew he was going to be out for pretty much the whole month of March, and I don't have an end to that. He hasn't responded thus far, so I believe he's still out, not engaged in work activities right now. Due to that, I extended the following offer. I said that Mr. Caldwell could choose to plead guilty as charged today, and we could close the case out with whatever time he has served since he's been in custody, I believe, on the violation in 1 day or so from his initial arraignment. He has, I believe, chosen not to do that. I did notify Mr. Drufus, who has passed that on to his client, that I will immediately reauthorize this case as soon as that officer is back so we can proceed to trial. None of those offers, of course, for time served or no upfront jail or anything like that would be the case at that time. So as soon as I find out when the deputy has returned, I will get this reauthorized and we will be back on the docket.
And you understand that a new bench warrant will issue for your arrest, sir?
Yes, Your Honor.
All right. Mr. Drufus?
Thank you, Your Honor. I did have some extensive conversation with Ms. McDuffie. I had brought this offer to Mr. Caldwell. And with the defenses that we believe we have in this case, he's made the decision to, if the prosecutor is unable to proceed to have this matter, we'd ask that the matter be dismissed on a motion.
Thank you. Given that the people are unable to proceed at this time, the court will grant your motion to dismiss. And it's without prejudice, meaning they can bring it back, and they've told you that they will be bringing it back. All right, you're all set. Your bond conditions will be over, sir. And if this is the only thing holding you, will be released. Okay?
Yeah, thank you. I'm thank the court too.
Thank you.
Thank you, Your Honor.
Thank you.
Rachel.
Thank you.
Ypsilanti Township versus Donovan Cox, case number 24T00043.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of Donovan Cox.
Thank you.
How y'all doing?
I'm pretty good. Please state your name, sir. Where are you?
Donovan Cox. Yeah.
Oh, there you are. All right. Thank you, sir. Please take off your hats. You're not wearing just one, you're wearing two.
Huh?
Please take off both of your hats.
Oh, sorry.
Thank you.
Hold on.
All right, we're here for a final settlement conference today.
That's correct, Your Honor. At this time, the township is not in a position to proceed.
We'll make a motion to dismiss. I'm sorry.
All right, given that the people are unable to proceed, I'm going to grant your motion to dismiss, sir. Your case is now dismissed. All your bond conditions are over. Those lien conditions don't get taken out of the system until in the afternoon. So please mind those conditions until later on this evening, okay?
Yes, ma'am. Thank you so much.
Thank you. Have a good day.
See ya.
Ypsilanti Township versus Jamari Hall, case number 23T00121.
Paul Barnett on behalf of the township.
Assistant Public Defender Dobby Lee on behalf of Mr. Hall. Mr. Hall, could you state your name, sir?
Jamari Hall.
Thank you. Good morning, Mr. Hall.
Good morning.
All right, we're here for final settlement conference today.
That's correct, Your Honor. At this time, the township is not in a position to proceed.
Your Honor, the defense would move to dismiss this time.
All right, given that the people are unable to proceed, Mr. Hall, I'm going to grant your attorney's motion to dismiss. The dismissal is without prejudice. So if they're able to proceed at a later date and time, they could reauthorize it. But as of now, all your bond conditions are over. And like I just told the other individual, that it doesn't get put in the system until later this afternoon. So please be mindful of the bond conditions until this evening.
Okay.
All right, you're all set, sir. Have a good day.
Thank you. You too.
Ypsilanti Township versus Gerald Hubanks, case number 23T00834.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of Gerald Hubanks. Mr. Hubanks, can you state your name?
Gerald Hubanks.
Thank you. Good morning, Mr. Hubanks.
Good morning.
We're here for a final settlement conference.
That's correct, Your Honor. At this time, the township is not in a position to proceed to trial.
We would make a motion to dismiss.
All right, given that the people are unable to proceed, I'm going to grant your attorney's motion to dismiss Mr. Hubanks. The dismissal is without prejudice, meaning that if at some point in time they were able to proceed, they would be able to reauthorize. Your bond conditions are now over, with the exception that it won't be in until this afternoon. So please be mindful until this evening. I see you have contact anyway. It's just no unwanted contact. So you should be okay.
Thank you.
Thank you. Have a good day, sir.
All right. Thank you.
Ypsilanti Township versus Stephanie Light, case number 23T00503.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of Stephanie Light. Ms. Light, can you unmute and state your name?
Good morning, Stephanie Light.
Good morning, Ms. Light. We're here for final settlement conference today, council.
That's correct, Your Honor. At this time, the township is not in a position to proceed.
We would make a motion to dismiss.
All right, given that the people are unable to proceed, I'm going to grant your attorney's motion to dismiss. The dismissal is without prejudice, meaning if they're able to proceed at a later date and time, ma'am, they could reauthorize. All your bond conditions are now over, so you need to be mindful that it will not really take effect until later this evening. So please don't have contact prior to that. If you do, I don't know whether you will or not. Okay?
No. Thank you. Have a blessed day.
You too. Bye-bye.
Wow.
Ypsilanti Township versus Sandra Mark Gray, case number 23T00337.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Miller here on behalf of Sandra Marcray. Ms. Marcray, can you state your name for the record, please?
Sandra Marcray.
Thank you. Ms. Marcray, good morning. We're here for a final settlement conference today.
That's correct, Your Honor. At this time, the township is not in a position to proceed.
Your Honor, the defense moves to dismiss.
And that the people are unable to proceed, I'm gonna grant your attorney's motion to dismiss. The dismissal is without prejudice, meaning that if they're able to proceed at a later date and time, then they could reauthorize these charges. Ms. McRae, I'm sure you've heard me explain the charges, that the lien conditions won't be taken out until this evening, so please be mindful of that, okay?
Thank you.
Have a good day.
You too.
Recalling the matter of the state of Michigan versus Kevin Allgood, case number 22S00659.
Rachel McDuffie for the people.
Sorry, having some trouble. Assistant Public Defender Sandra White on behalf of Kevin Allgood. Mr. Allgood, if you can unmute and state your name again.
All right,
I don't know why it takes so long to unmute.
that's okay.
Kevin, Scott, all good.
All right, thank you, Mr. Allgood. All right, Ms. White, where are we with this, please?
We do wish to go forward to trial, Your Honor.
Jury selection on this matter will be May 3rd, 2024 at 8:30 a.m. We'll see you then. I'm
Thank you.
sorry, I did that wrong. I'm so sorry. We're scheduled for April 5th. April 5th, 2024 at 8:30 a.m. Okay? You want it then, right? Or you want the May 3rd date, Mr. Allgood?
I'm not even sure, Your Honor, that I have the right attorney. It seems the attorney's, my own attorney's against me. So I wanted to talk about the case and all that. And she hasn't even called me to talk about anything about the case. It's over a year old, Your Honor.
I understand, sir. So my question still is the same. Do you want it on April the 3rd? May 3rd or I'm sorry, April 5th or May 3rd? Which one would you?
Your Honor, I would like it further away so I'd have more time to do my case, ma'am.
Okay.
Your Honor, remember the officer isn't available in May. Okay, so are we moving to the May 3rd selection date? I see. Okay.
May 3rd, 2024.
Thank you, Your Honor.
8:30 a.m. All right. And we'll go from there. We'll see where we are. Mr. Allgood, okay?
Thank you. Thank you.
All right, thank you. All right, State of Michigan versus Damon Camp Krager, 22S00097, as well as Ypsilanti Township, 22T00300.
Rachel McDuffie for the people.
Paul Barnett on
Assistant-
behalf of the township.
Sorry, Paul. Assistant Public Defender Allison Muller here on behalf of Damon Camp Krager. Mr. Camp Krager, can you state your name for the record, please?
Yeah, Damon Camp Krager.
All right, we're here for final settlement conference. And one case, that's case number 22S00097, all in both cases.
Thank you, Your Honor. The people are unable to proceed on the state matter.
And Your Honor, as it relates to the township matter, the township is also unable to proceed.
Your Honor, the defense moves to dismiss on both matters.
Given that the people and the township are unable to proceed, I will grant your attorney's motion to dismiss both of these matters. They are both dismissed at this time. All your bond conditions will be out of lien by this afternoon, okay? By this evening, sir. So please keep that in mind, okay?
Thank you very much.
You're all set. Have a good day.
You too.
Ypsilanti Township versus Shayna Lawson, 22T 00708.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Muller here on behalf of Shayna Lawson. Ms. Lawson, can you state your name for the record, please?
Shayna Lawson.
Good morning, Ms. Lawson.
Good morning.
All right, we're here for final settlement conference today.
That's correct, Your Honor. I believe we have a resolution. The offer would be that people would amend and add account 2, operating while visibly impaired. That's 93 days, $300 in exchange for a plea of guilty to that added count 2. The original count 1, operating while intoxicated, would be dismissed.
Ms. Lawson, is that still how you want to proceed? You want to accept the offer to operating while visually impaired?
Yes, so that's like 6 points on my
I believe that it is a 6-point offense. Mr. Barnett, I'm sorry, do you know off the top of your head, is that 6 points?
Give me one moment. I don't think it is. I think it's 4 points.
4 points.
Okay, thank you.
Thank you for confirming that.
Yes.
All right, ma'am, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. All right, ma'am, it's my understanding you're going to be pleading guilty to an added count 2 of operating while visibly impaired. That is a misdemeanor still. It carries a maximum penalty of 93 days and up to $300 fine plus court costs. In exchange for that plea, count 1, the more serious offense would be dismissed. I also just informed you that it is a 4-point offense, meaning you'd have 4 points on your driver's license because of that. There may be other repercussions from the Secretary of State as well. Do you understand that?
Yes, ma'am.
All right, is that what you want to do?
Yes.
All right, I'm gonna go over some rights that you have that you're gonna be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay?
Okay.
You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself, or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand all those rights?
Yes, ma'am.
You understand you're going to be giving up each and every one of those rights, ma'am, and you're not going to be having a trial of any sort?
Yes, ma'am.
You also understand that there's no automatic right to appeal this decision. So the decision that you're making today, in all likelihood, is going to stick with you.
Yes, ma'am.
And do you also understand if you're on probation, parole, or bond on the date that this offense occurred on July 31st, if you were on probation or parole or bond then, and you still are, you could be in violation of it. Were you on any that you're still on now?
No.
And in addition to that, ma'am, if you're not a U.S. citizen, you could have immigration consequences. Are you a U.S. citizen?
Yes.
All right. To the charge of operating while visibly impaired, how do you plead?
Guilty.
Anyone promise you anything other than what we placed on the record to get you to plead guilty?
No, ma'am.
Anyone threaten you in any way, shape, or form?
No, ma'am.
All right, thank you. So let's turn to the date of offense itself. On or about July 31st, 2022, were you operating a motor vehicle at the vicinity of East Cross Street and Prospect here in Ypsilanti Township, ma'am?
Yes, ma'am.
And at the time you were operating that motor vehicle, were you under the influence of alcohol?
Yes, ma'am.
Was there blood alcohol content done, the test done?
Your Honor, there was actually a breath data master test in this case with a test result of 0.15.
Thank you. You stipulate to that, Ms. Muller?
I do, Your Honor.
All right, I find that there's a factual basis for the plea. It is willingly and knowingly made, and I will accept your plea. Ma'am, are you satisfied, Mr. Barnett, that I met the court rules?
Yes, Your Honor. Thank you.
Ms. Muller?
I am as well, Your Honor.
All right. Sentencing in this matter will be, well, before we do that, let's address the fact she missed a number of tests.
I missed the number of what?
Testing. Are you in treatment right now?
Mm-hmm.
Okay, that explains that. All right. All right. Sentencing in this matter will be on May 1st, 2024. at 10 o'clock a.m. You need to make and keep an appointment with the probation department. Do you have their phone number, ma'am?
I have the lady that I go test to, I have her card.
No.
I what? No.
Let me give you a new phone number.
Miss Allison, can you text that to that number? Cause I'm in someone's office and I don't want to go through their doors.
Yeah, I absolutely can. Your Honor, I will send her the message right now over text.
All right.
Or the number.
Please call them on Monday to schedule an appointment. I've been telling people to call on tomorrow when we're actually closed tomorrow. So you need to call on Monday to schedule an appointment to have if you don't have an assessment, which you probably do, to have an alcohol assessment done. If you have an assessment, you need to get that to the probation department. But in any event, we will see you back here on May 1st for your sentencing.
May 1st at what time?
10 a.m.
10 a.m.?
Yes.
Okay.
Thank you. Have a good day. Count one.
Thank you. Miss Allison, I'm gonna be calling you in a little bit when I can use the phone.
Sounds great.
All right. Have a good day.
Thank you. You too. Court will call the case of the state of Michigan versus Anthony Smith, 23S00394.
Your Honor, can we also call the co-defendant in approach, please?
McRae. Court will also call the matter of the state of Michigan versus Shatara McRae, 23S00397, as well as ticket numbers 14S120866 and 4961, 20W001669.
Paul Barnett on behalf of the township on the show cause matters. Your Honor.
Thank you.
Go
ahead, Ms. White.
Assistant Public Defender Sandra White on behalf of Shatara Magbrae on 23S397.
Action would appearing with on behalf of Mr. Smith, who's also present by Zoom. Mr. Smith, can you state your name for the record?
Anthony Smith.
Thank you, Mr. Smith. Ms. McRae, please unmute and state your name.
Shatara McRae.
Thank you. All right, we'll go into a breakout room at this time. Okay.
Your Honor, you're muted. Yeah.
The court is back on the record in the case of the state of Michigan versus Shatara McBray as well as Anthony Smith. We've had a long breakout room regarding these matters. It is my understanding that after having some lengthy discussion about the posture of the case, the next step of action is going to be that counsel will be preparing, and I think Ms. Hammoud has volunteered to take the lead on this, an order effectuating the rulings from the hearings that we had back on March 14th, 2023 regarding 404B evidence. That order hopefully will be provided to this court with any success by the end of today, but if not, no later than Monday, so that Ms. McDuffie can decide, or I think she's preparing a motion for reconsideration of some sort, and the court will try to make a ruling on that motion as soon as possible. We're going to continue this case on to the hearing date of April the jury selection date of April the 3rd, 2024. Ms. McDuffie's also made a April 5th. I keep wanting to say April 3rd because of the May 3rd date, and I think my mind's moved there. April 5th will be the jury selection, April 5th at 8:30. Ms. McDuffie has also indicated that she may or may not, and she's not certain yet, have some issues regarding witnesses for trial during the month of April. That issue will be addressed on the morning of the jury selection as well, and counsel will be able to make any arguments that they may have in the event she can't go regarding that. And it is possible that this case may not go at that time because there may be an appeal, an interlocutory appeal, I guess, where the court would have to stay. The circuit court would need to stay this matter for that appeal to occur. So having said all that, at this point, we're still on schedule for the April 5th jury selection with an order to come by no later than next Monday, so that Ms. McDuffie can file whatever she needs to file with respect to these matters. Mr. Barnett has been tagging along with us for all these arguments on his show cause, but I'm certain he found this very interesting and enlightening.
Indeed.
And I will see you all on April the 5th at this point at 8:30 a.m. So, Mr. Barnett, you don't have anything that's scheduled yet.
Yeah, I don't, Your Honor.
And I don't know whether you will or not, but if you don't, you don't have to be present on that day. I'm going to adjourn your show causes to that day and time as well, but you do not need to be there. Okay?
Thank you, Your Honor. I appreciate it.
Your Honor, is jury selection at 14B or at Service Center?
At 14B.
Thank you.
I will see you all at 14B here at the, they are held in the boardroom, just so you know.
Thank you.
Thank you.
Thank you, Ms. McBray. I'll give you a call.
Okay.
I think I did. Doesn't matter, I got it. It's the one. With the rest of our document. State of Michigan versus Roderick Simpson, case number 23 FB 2434.
Rachel McDuffie for the people.
Assistant Public
Hello,
Defender.
how you doing today, Your Honor? Hello?
Just a second, Mr. Simpson.
Oh, I apologize.
Assistant Public Defender Sandra White on behalf of Roderick Simpson. Mr. Simpson, you can now state your name.
Yes, my name is Roderick Simpson.
Thank you. Good morning. Good afternoon, Mr. Simpson.
How you doing today, Your Honor? You doing good?
I'm good.
That's very excellent.
We're here for a final settlement conference today. Where are we with this matter, please?
The people are unable to proceed in this matter.
Defense will make a motion to dismiss.
All right. Given that the people are unable to proceed, Mr. Simpson, I'm gonna grant.
Yes, ma'am. Oh, yeah, I got to bring my princess with me, you know what I'm saying? Keep my babies with me. Oh, sorry, Your Honor.
All right, this case is now dismissed. All your bond conditions are now over. Take care of yourself. You look like you did not post any money, so you're all set, sir. Have a good day.
Okay, you too, Your Honor. I got a question to ask you, Your Honor. Okay, so after I'm done with y'all, do I got to come back down into corrections to get this box off my leg?
Yes, sir. Thank you for telling us that you have a tether. We will send
Yeah,
an
because
order.
y'all had the tether on me, even though I had the PR bond, but you said that it was still steady because the judge said that, she gave me the PR bond. So I was just wondering, like, do I come down there and just take it off, or how I go about that?
Go to community corrections. Do not go after. Hold on one second. All right. Do not go after about 2 o'clock today. You can go after 2 to get it taken off. Okay, sir?
Okay, so you said go after 2?
Yes, sir.
Okay, I have a question. If I can't make it today, can I get it taken off tomorrow morning?
Yes, sir. You can.
Okay, thank you so much, ma'am. I appreciate you.
Have a good day.
All right, you too, Your Honor. Thank you. Thank you. That's a good.
The court will call the matter of the state of Michigan versus Cody Feather, case number 23-00509.
Rachel McDuffie for the people.
Assistant Public Defender Allison Miller here on behalf of Cody Feather. Mr. Feather, can you state your name for the record?
Cody Feather.
Thank you. All right, we're here for final settlement conference today.
That's correct, Your Honor. I had previously extended an offer to Mr. Feather as we had a request. I think that he engaged in some treatment and no jail. And the offer reflected that. I did inform Ms. Moeller right up front. I noticed this right immediately with this file that Mr. Feather had, I believe it is 3 prior convictions that would count towards the status of the current case. And so Mr. Feather was informed and was aware, and I think that he made a knowing decision to reject that offer, and knowing that this case was going to be reauthorized as the felony. So this has been, per his wishes, reauthorized as a felony DV third. I do not see it entered yet in JIS. It should be there any minute or any day. So the people will not be proceeding in this court on this matter unless and until it ends up being remanded back to this court, if there is a need for that, following any other proceeding.
All right. Given that, this case is dismissed at the prosecutor's request, correct?
Yes, Your Honor.
Thank you. Case is dismissed here, sir. You can deal with them at the felony division. Okay? All your bond conditions here are over.
Okay, Your Honor. What's my next step? Because I'm not one of them catch me if you can kind of guys. What's my next step? Do I go to the felony division and try and turn myself in, or?
I'm going to let you speak with your attorney who can give you legal advice as to what you should do next, okay?
Okay,
Mr.
thank
Feather,
you.
I'll give you a call after court, okay?
Sounds fine. Thank you.
Thank you. Have a good day, sir.
You too. Thank you. Bye.
State of Michigan versus Eli Green, case number 23-00533.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Eli Green.
Eli Green.
Thank you. Hello, Mr. Green. We're here for, I'm pretty good, sir. We're here for final settlement conference today.
Yeah, the people are unable to proceed on this matter.
We will make a motion to dismiss.
Given that the people are unable to proceed, I'm going to grant your attorney's motion to dismiss. The dismissal is without prejudice, meaning that if they're able to proceed at a later date and time, they could reauthorize these cases. This case, do you understand that, sir?
Yes, ma'am.
All right. Your bond conditions are now over. This wasn't holding you in custody anyway.
No.
All right. You're all set, sir. Have a good day.
You too. Thank you. Appreciate it.
State of Michigan versus Brian Johnson, 23-00071.
Rachel McDuffie for the people.
Assistant Public Defender Dappy Leba on behalf of Mr. Johnson.
Mr. Johnson, please unmute your device and state your name.
Brian Johnson.
Thank you. Are we here for final settlement conference today?
Sorry, I was muted. Yes, Your Honor. The people are unable to proceed at this time.
The defense will move to dismiss at this time.
All right. Given that the people are unable to proceed, the court will grant your motion to dismiss. The dismissal is without prejudice, Mr. Johnson, meaning that if you are, if they are able to proceed at a later date and time, they could reauthorize these charges. All of your bond conditions are now over. And you didn't have to tether anything, did you, sir?
No,
All right, you're all set, sir.
thank you.
So as a reminder, the conditions won't come off of lien until later on this evening, so you should be mindful of them until then, okay?
All right, thank you.
State of Michigan versus Anthony McFarland, case number 23 FB.
Richard McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of Anthony McFarland. Mr. McFarland, can you state your name for the record, please?
Anthony McFarland.
Thank you. We're here for final settlement conference today.
The people are unable to proceed at this time.
Your Honor, the defense would move to dismiss.
All right, given that the people are unable to proceed, sir, I'm going to grant your attorney's motion to dismiss. The dismissal is without prejudice, meaning that if they're able to proceed at a later date and time, they could reauthorize this case. It looks like I'm trying to make sure that you came from the circuit court, so I'm trying to make sure you're not on tether or anything like that, are you, sir?
Yes, I actually am.
All right, then we need to send over a tether order to get that removed, and we'll do that. You can go over this afternoon after 2, 4, 3, 2. Okay, after 2 p.m. today to get that taken off. Okay.
What's the latest I can go? Because as you can see, I'm currently at work. So I just want to say that again.
4:30 is the latest. I'm sorry. You have to be there by 4 for them to get it done.
Okay, so this is my only problem. I work 12 hours, so I work like 6 to 6, all like Monday through Friday. So I'm trying to figure out what is going to be a good time or day to get it removed.
Well, you'll have to work with your work, sir, to get a time to you to go over to do that. It has to be between. Was the tether ordered in this particular case, sir, or do you have another matter that's pending?
No, it's this case.
Okay.
So I just have to make sure it's in that time frame.
Yes, sir, you do.
Okay, then. Thank you so much.
All right. Thank you. State of Michigan versus Bruce Kennedy, case number 20S00217.
Richard McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of Bruce Kennedy. Mr. Kennedy, can you unmute and state your name, please?
Yes, Bruce Kennedy.
Thank you. We're here for final settlement conference.
The people are unable to proceed at this time.
Your Honor, the defense moves to dismiss.
All right, given that the people are unable to proceed, sir, I'm going to grant your attorney's motion to dismiss. The dismissal is without prejudice, meaning that if at some point in time they are able to reauthorize, they could reauthorize this case. It looks like you had a PR bond, but there were no, you weren't on tether or anything, were you, sir?
No, ma'am.
All right, thank you. Your bond conditions are now over. This case is now dismissed, so you're all set.
Thank you.
And I think that is the totality of our docket. So we're all set.
It is. Thank you, Your Honor. I just have one more question, unrelated, but the court got the correspondence yesterday regarding Ms. White. I know Mr. Burkhead is not here, but he was copied.
What's that?
I don't know what you're.
I'm sorry, not you, Ms. White. Defendant named White. Yeah.
Oh, yes, I did get that. I did sign that order on those matters.
Oh, so you did want her to not test?
What?
What?
No, I just got an adjournment request, which I signed.
I'm sorry. Mr. Burkhead has 2 clients named White too. That I just realized that. Not that one, Kelly White, regarding her testing order. I'm sorry.
Let me see what I have here.
I didn't realize how many Whites it was when I started talking. It's from me yesterday at 11:44 a.m.
So I'd have to pull this file, and I can't talk to you about the substance of it without someone else being present.
I just wanted to make sure you had the email.
I have it now. Yes.
Okay.
Okay. All right. All right. Thank you.
Mhm.
I think that's it then.
I think so.
Bye, everyone. Bye-bye.
Have a good afternoon.
Did you find the order for that?